Hey there, thank you so much for downloading the Legal to Launch Masterclass. We have a lot of information to get through today, so I'm going to share my screen with you and we will dig in. So today we're going to talk about how to set up and run a legally protected and compliant business. This might not be the most exciting part of starting a business. It's not like Facebook ads or email marketing or social media, but it's really important that you get your ducks in a row early on so you can have confidence moving forward and treat your business like a business and not a hobby. So we have a lot of information to get through today. We're going to talk about choosing a business structure, choosing a business name and trademark registration, the biggest contract mistakes businesses make, what contract clauses you need, policies to protect your business, legalities of email marketing, and protecting your original work online. So you may have watched a lot of webinars where they give you little tidbits of information and then you need to buy their program to really learn the secret sauce. And this is not that kind of webinar. This is something that is really going to be a knowledge resource for you. You have the link in your email. You can come back to this link. It's evergreen whenever you want to check in, refresh your knowledge. This is really about professional development. I am a trademark attorney, so I offer that as a service. And I also offer contract templates and website policy templates if you feel you need them. So I offer that, but this is not what that's about. This is really about empowering you with the knowledge that you need to really build a business. So whether you're at the beginning stages of your business, you haven't launched, or you're just launching, or you're growing your business, this is going to be information that's important for you. But first, a quote from Benjamin Franklin: "An ounce of preparation is worth a pound of cure." And what does this mean? This means that it is better to, put in a little bit of time now to make sure that you are checking those boxes, that you're protecting your business legally, and that you don't run into a problem down the road, because even to the extent this requires an investment, it's a slither of the investment that it may take to solve a problem later on if you're involved in litigation. So if we are just meeting for the first time, my name is Kaylee Jacome. I'm a small business attorney. Like you, I had dreams of starting a business. So I was working long hours as a trial attorney. I was a federal prosecutor for the Department of Homeland Security in New York City, and then I was an assistant attorney general in St. Louis. And those were great jobs. They were very challenging, but I was driving to work every day, and not feeling like it was what I was meant to do my whole life. And then when we were planning for our first child, my daughter, who's now two and a half, I just knew that I needed to create a career, create a business for myself that was going to fit my vision of motherhood. I was working really long hours, and she was going to need to be in full-time daycare unless I created a business that was going to be flexible for our life. We also like to travel. I have a background of working internationally in trademark law, in intellectual property law in Asia, and I just wanted to create a business that was going to, reflect the dreams that we had for our family. So I did that, and you can do that too. So the first thing that you want to think about when you're starting a business is choosing a legal entity. This is how your business is going to be organized. So we're going to talk briefly about sole proprietorship, LLC, a limited liability company, partnership, or corporation. Most of us, when we're starting a business, are going to be choosing between a sole proprietorship and an LLC. So we're going to talk about how to make that choice specifically later on. So first, we're going to talk about a sole proprietorship. So there's some pros and cons to each business structure. A sole proprietorship is an automatic form of business. So if you start selling your services or selling your goods and you haven't done anything to register your business, you are automatically a sole proprietor. So whether you go to the farmer's market and you're selling, some necklaces that you made or something, you're a sole proprietor if you haven't registered a different type of entity. If you are selling virtual assistant services online and you offer those services and someone pays you to do that work, you are operating as a sole proprietor. So it's a very simple, it's an automatic form of business. Your state, depending on what state you live in, may have a requirement for you to register your business as a sole proprietor with the state. However, that doesn't make you a sole proprietor. So registering doesn't make you a sole proprietor. You're automatically a sole proprietor when you start doing business. And that requirement is just a requirement to comply with your state law. So it's possible, if you don't register that, to be a sole proprietorship, but one that is not complying with that requirement in your state. So you want to speak to a business attorney that's licensed in your state, or you may be able to research that yourself online to find out what the requirements are. Generally, you can go to your state's Secretary of State website, and usually you can find information there. So also, it's very cost efficient. There's no fees to creating a sole proprietorship, other than the other expenses of creating a business, because you are a sole proprietor automatically. And of course, that makes it easy. The cons of a sole proprietorship are that there is no separation between you and your business. You are your business is you. So all of your income is going to, passes directly to you, to your personal income, and it's taxed that way. But if you get involved in a problem down the line, whether that be creditors, bank creditors, someone you owe money to, or a legal judgment against you that came out of a lawsuit, then your personal assets are on the line. They are exposed from any business liabilities. So you have no protection there. Again, you are your business is you. But the benefits, again, are that ease. You don't need to be filing any special paperwork that we'll talk about with other entities. So then your next option is to operate as a limited liability company, an LLC. This is probably the most popular business choice if you're going to choose to become a separate entity and not operate as a sole proprietor, an individual. Usually an LLC is a popular choice for small businesses. So the pros are that rather than you being your business and your business being you, there's some separation. So when you form an LLC, you register that through your state, and it's like you had a little baby. So there's this little baby over here that's the LLC. It's separate from you. So what that means is if there are creditors coming after the business, or if you have a judgment against you from a lawsuit, and of course we all believe that we're never going to do anything wrong, we're never going to mess up, but we can't predict the future, right? And sometimes things don't even work out fairly. So you need to be aware of those risks. And what an LLC does is it's going to separate your personal assets, so your home, all of your personal assets, from the business liabilities. So if you are sued, the only thing that they would be able to recover are your business assets, not your family's personal assets, which is a huge advantage. But with that separation comes requirements and responsibility. So because it's a separate entity, you actually need to treat it as a separate entity. Your banking needs to be completely separate. You can't be commingling your personal expenses and your business income together. They need to be separated out. This needs to be treated as its own business. You also need to make certain financial disclosures, but there are things like an operating agreement that you may need to file separately with the state. So you may need to create that document, either working with an attorney licensed in your state, or there are templates online if you feel comfortable customizing that to your business and file that. Some states, if you are a single member LLC, so it's just you, they won't require that you actually file your operating agreement. However, it's still very important that you have one, and that you have one for your own records, because again, in that situation where your business may be sued and you have a separate LLC, so all they can go after are your business assets, not your personal assets. If you don't have substantial business assets and you have substantial personal assets, someone may try to basically say that your LLC is just a formality, that really you've been running your business as a sole proprietor, that you haven't separated the businesses out, and that you are acting as an individual through your LLC. And they ask the court basically to disregard your LLC status, which is called piercing the corporate veil. So they're saying, you've commingled resources, you haven't acted like this is a separate LLC, so you shouldn't be afforded the legal protection of an LLC. So that's not a good situation to be in, and that's why you want to make sure that you follow all of the rules and the requirements of having an LLC. If you were that single member LLC and your state didn't require you to file an operating agreement, in this situation, it's a good thing to have had in your records, dated when you began this business, when you registered your LLC, that you can, pull that out and just add it hopefully to many other points of proof that, yes, in fact, you were an LLC that was operating by the requirements of an LLC. Now, the cons are that it is more costly. So filing fees will vary state to state. It could be from $100 to several $100s. And of course, more requirements. So filing those forms, financial disclosures, making sure everything is separated out. There also, taxes are handled in a different way. And I would recommend that you consult a CPA to discuss your unique tax circumstances and whether an LLC or sole proprietorship would be appropriate for you. So, partnership. Now, partnership is a term that is used a lot, especially in the online world, but in businesses when we're talking about collaborating. So collaborating and working together on something is not necessarily a partnership. Partnership is a legal term that refers to its own business entity. So if you are in a partnership, you are in business with another person or multiple other people. So if you're intending on, collaborating with someone for a project or something like that, you don't want to call it a partnership. These are important things, to make sure that you work with an attorney or, that you get straight in your business so that there aren't legal implications to the words that you're using if you're not actually intending on forming a partnership. So a partnership is like a sole proprietorship, like the first entity that we talked about, except that it has multiple people. So the profits are going to be divided by those people, and it's going to be reflected on their individual tax returns. And then each partner can be held liable for partnership debts and actions. There are different types of partnerships. You can be a limited partner. For most people starting a business, this isn't a very common type of business form that you would select. Even if you are going to have multiple people involved in a business, usually you're just going to be a multi-member LLC. A partnership is generally in a professional partnership entity like a law firm or something like that. But for most people, this isn't going to be a common entity that we're going to be choosing of. And then corporations. So corporations, we think of them as being these, big multi-million-dollar corporations. And if that's your goal, I certainly hope you will succeed in that. But you can form a corporation even if you're the only person in your business and you're basically a single shareholder. You own all the stocks to your business. There are different types of corporations. You may want to form a C Corp or an S Corp. There's also something called a B Corp, which is available in certain states. I believe it's 19 states currently. But basically a B Corp it stands for benefit corporation, and think social enterprise. So that's for corporations that have some type of social cause that is, a core value of their business that they're operating under, but they're not a nonprofit. And certainly that's another form of business that's a corporation usually, but a not-for-profit corporation. And we won't get into that, but one of the main reasons why you might want to form a corporation rather than an LLC. So a corporation is going to afford you, again, that separation between your business and yourself. So your personal assets are not going to be liable for business judgments or creditors. But if you are looking for outside investors, so think like Shark Tank. So you're looking for capital investments coming into your business. So really that like kind of classic startup. This might be a good business choice for you. Also, depending on your tax situation, you may want to choose this option. So I encourage you to work with an attorney, again, licensed in your state, or your CPA when deciding whether a corporation is right for you. It will come with many, many more requirements, even more so than an LLC, to comply with all the requirements of being a corporation. Okay, now, so like I said, for most of us, we're going to be choosing between a sole proprietorship and an LLC. So how do you make the decision of which is right for your business? We want to consider simplicity, cost, protection, professionalism. So simplicity. Of course, a sole proprietorship is going to be the simplest choice. You're automatically going to be a sole proprietor when you start doing business. Costs. Sole proprietorship is going to be cheaper. An LLC is going to involve some filing fees, and those will vary by your state. For the most part, they tend to not be, too substantial, but I will say that we currently live in Illinois, and the filing fees for an LLC are quite high. And I can imagine, if you were on a very tight budget, how a couple $100 might not be something that you want to jump into. You might be considering operating first as a sole proprietor and becoming an LLC later on. Really, the choice comes down to what level of protection you need. So you're going to get more protection out of an LLC. Your personal assets are going to be insulated from those business liabilities as long as you're following the LLC requirements. So it's really about risk mitigation. And you need to think about how high is the risk that you're going to be sued. So in this analysis, you want to consider, well, what services are you offering? What goods are you offering? How likely is it that someone is going to sue you? Now, of course, we hope that we're not going to be sued at all, but these things happen. So, an example of, let's say you're running a at-home daycare, I would definitely want to be an LLC. Anytime people are coming onto your property, be it your personal property or business property, you want that added protection, because that's just more opportunities for things to go wrong. Now, if you're working as a virtual assistant, let's say you're doing social media management or something like that, there are still opportunities for you to be sued. Especially I think with social media management, maybe copyright infringement, maybe if you unintentionally used a work that belonged to someone else and you used it for your client, and your client got in trouble for committing copyright infringement or something like that, and it really came from your actions, then you might be responsible for that. So certainly there are things that can come up, but I would say you have less exposure, you have less of a risk of being sued in that type of business than if people are coming on your property. But again, it's all about really looking at your individual services. And also, some people think that it's relevant to consider what assets you have. So if you have substantial personal assets, if you're very wealthy, some people are of the mind that you have more to lose, so more to protect. I don't necessarily subscribe to that, because let's say that you had a judgment against you and you didn't have substantial assets. Let's say you don't have any money at all, so you have nothing to lose, or you think you have nothing to lose. When you have a judgment against you, as you earn money, that can now be at risk. So just because you don't have money now doesn't mean that, as you come into money or as your business grows, et cetera, that you're not still going to be responsible for that judgment, because you will be. So really, I think it comes down to risk mitigation, considering, the cost of an LLC and your risk of being sued. If you can afford the LLC fee, I think generally it's a good idea for most businesses. And of course, professionalism. So again, not that it's unprofessional to operate as a sole proprietorship. An LLC, maybe gives you the appearance of being more of an established business and things like that. So all things to consider. Now, choosing a business name. This is one of the fun parts. So usually when we have a new business idea, one of the first things we all think about is what we're going to call this new business. What is going to be our business name? And it's easy to get very emotionally attached to that name very quickly. You kind of tie up all of your hopes and dreams for this big business in this name that is just like capturing the essence of the soul of your business. And you want to make sure before you get too attached to that name that it's available. And a couple other considerations that we'll go over. So your business name should be distinct. So especially if you are starting a business where you really want to build a brand, and that might be around a product, but it might also be around a service or a community or a membership site, an online course. And even if you're just a service provider now, think about ways that you might want to expand your business going forward. So when you're a service provider, your time is really connected. The money you make is connected to your time, right? So you're trading time for money, and that's wonderful. You know, it's amazing to be employed for yourself, set your own hours, and do what you love. And especially if you have a high value offer, so you have a high fee for your services. Maybe you don't starting out, but as you build up your clientele, as you build up your brand notoriety, you're going to be able to raise that rate. But to a certain point, you are capped at your own time. So after that point, you either, you can kind of form an agency, so you can have freelancers working for you, where you're bringing in the clients, you're offering, the umbrella service, and then you have other freelancers that are helping you fulfill those services. Or you can go to a model or add in a component of your business where you're making passive income. So maybe that's an ebook, maybe that is an online course where you're teaching people how to do what you do, or you're teaching them how to do what you teach your clients. Or a membership site where you're offering them, a lot of resources, and they're paying a monthly fee to be a part of that membership site. So these are all ideas that you might have, going forward. And it's useful to take a minute, especially if you're wanting to really build a brand and be known for this dream that you have, to consider all the services that you might want to provide, and choose a business name that is going to give you some latitude, so give you some flexibility. Now, of course, you can always start a new business. I have 3 businesses, so you don't need to have this name encompass anything you may ever do. But, just don't limit yourself too much to what you're doing right now, and consider how it might expand. And so that was a little bit of a diversion on my point of being distinct. But if you're trying to build a brand, you may want to trademark that name. And one of the requirements of a name to be able to get federal trademark registration for it is that it be distinct. So it can't simply just describe your business. And that's actually my 4th point, not just to be descriptive. So for example, let's say you're going to be a virtual assistant, and let's say you're going to call this business Grace and Grit Virtual Services. I don't know. So virtual services, that's just describing your business. It's not very distinct. Perhaps the Grace and Grit is distinct, although I feel like I've heard that in many places. But and so next point, original. Being original. You don't want to, not only do you not want to steal someone else's name identically, but you don't want yours to be too similar either, because the standard for trademark infringement is not whether the 2 names are the same, but whether a consumer is likely to get them confused. So even if they're not identical, they may still be too similar, which might mean that you're committing trademark infringement. And if you were to go to register that name to get federal trademark registration, you might be rejected based on the likelihood of confusion standard. So they're saying there's a likelihood of confusion between these 2 names. So when you do a trademark search, you want to make sure that you're not just searching for identical names, but you actually want to get out a piece of paper, write down all possible synonyms, and then cross-reference those and search for different combinations of them. You want to make sure it's original, because you don't want to be in the position where you start building this company, especially if you have a product. Let's say you have a skincare line, and you are printing that name on all of your labels. So you've invested a lot in inventory, or even if it's just an Etsy shop or something like that. Not that Etsy shops are just Etsy shops. That's a really great way to build a business, a profitable business. And let's say that you have labels, on t-shirts or something with your business name, and you've invested in this, and then you find that the name is already taken, or you get a letter from the other business owner asking you to stop using that name. Now you're going to not only need to rebrand, but you're going to need to reinvest in all of that inventory. And again, even if you have an online business that's service-based or learning-based, you are building credibility and you're building notoriety around this name, and you don't want to have to switch names and, bring your audience over to a new brand. You want to make sure it's available and original in the beginning. And then the next thing is your name should be on brand. So when you're thinking about a business name, you don't just want to think about the name, you want to think about what you want your website to look like, what you want people to think about when they think about your business. So let's say, back to the Grace and Grit example, Grace and Grit Virtual Services. Let's say that that's the business name that you're thinking of, but your website and your branding and the look of your business is very like urban. It has a very like urban city, cosmopolitan feel to it. Maybe that Grace and Grit doesn't quite seem on brand to that. It doesn't sound urban. It sounds, to me, it sounds more like, farmhouse chic or something. Sounds more like a fixer-upper type brand than this urban kind of brand. So just considering, like the colors you want to be using, the images and the feel of your brand overall, and making sure that your name matches up to that. Okay, and lastly, should you include your personal name in your business name? You can certainly operate your business as your personal name, whether you're a sole proprietor or you're an LLC. So for example, Contractista is my business. It is a trademark, it's a DBA, but the business behind Contractista is Kaylee Jacome LLC. That's my name, and it's a limited liability corporation. So you can certainly register an LLC in that name, and you can do business publicly in that name. So if you were going to be a virtual assistant, it could just be KayleeJacome.com. You can certainly do business in your personal name. Now keep in mind that won't be trademarkable. Your personal name can't be trademarked unless you reach a certain level of celebrity status. And that's fine. You don't necessarily need to trademark your name if you're using your personal name. And we'll talk about that a little bit more. Trademarks. So we've already delved into this topic a little bit, but let's go over some points of why you should register your trademark. Again, not everyone needs to register their trademark, specifically because not every name is trademarkable. But what are the benefits to doing so? Well, you put the world on notice that your name and your logo belongs to you. So again, not necessary if you're using your personal name. You also prevent others from using your trademark for similar goods and services. Now, when you start using a name in commerce, if it's a trademarkable name, you will have common law rights to it as soon as you start using it, as long as there's not a prior user who has superior rights. So basically, if the name was available for those goods and services, once you start using it, you have common law rights. But there are a lot of reasons and benefits to registering your trademark with the federal government. And one of those is that you put others on notice. So if you go to, let's say, you're a billionaire barista, and then someone else independently thinks of that name, and they come to the federal database to do their search, and they're a well-intentioned person, they're trying to do their due diligence, and your name doesn't come up in a search because you haven't registered yours. And so they think that the name is available, and then, in good faith, they start building this business around this name, and then down the line, your two paths cross, and now you're in a trademark dispute with this well-intentioned person. You both may be well-intentioned people, but you're using the same name or very similar names, and it's causing issues, and one of you has unknowingly committed trademark infringement. The other person unknowingly committed trademark infringement because your name wasn't registered and they didn't have notice of it. So another reason to avoid disputes and lawsuits with others. Protect your brand's reputation. So when you register your trademark, you're not just stopping other people from using it because you want to just be the only one using it because you love your name and you're connected to that, but you also have built a certain reputation around it. When people think of your business, they think of certain attributes of, the goodwill that you've built with them. So as you may see, I really love coffee. So we're going to do another coffee example. Let's say, I don't know if you're a Starbucks girl or a Dunkin' girl, or maybe you don't like coffee at all, but we all know that these two brands offer a different brand experience. So Starbucks, usually it's more expensive. There's kind of like that coffee house, remote work kind of feel to it. That Pacific Northwest kind of more trendy feel. And then Dunkin' Donuts is like a quicker experience. Obviously you have your donuts. It's kind of like a quick, get in there, get your coffee, go. The products of both are good. They're very consistent. You can pretty much go into any Dunkin' Donuts or any Starbucks, order your drink, and you're going to get, consistency in what that tastes like. But they're two very different brands, and people go choose one over the other for different reasons. So you spend time building your brand's reputation and what people think about your business when they see that logo or when they hear your name. And so if someone else is using a similar business name or the same business name, and they are doing things very differently in their business, not the way that you would do things, and people are getting confused about the source of those services, or they're getting the two businesses confused, that potentially hurts your reputation, because you don't have control over that brand impression. And then that kind of just ties into to build a powerful and recognizable brand. And then lastly, add value to your business with a federally registered trademark. So by add value, I don't mean in the fluffy way of like delivering value, which you should do in your business, but I mean like tangible financial value. So most of us, when we start a business, never think about one day selling our business, like selling a profitable business. But that's kind of a cool thought, huh? If you spent years, building a really successful business, and maybe it's time for you to move on to something else, but you have this business here that you could sell, that's profitable. And you could take that money and, reinvest it into another business, do whatever you want with it. By having a federally registered trademark, you are adding value to the valuation of your business. Okay, so if you decide to register your trademark, it is a bit of a process. We'll go through this pretty quick, but so first you want to do a search. Like I said, you want to make sure the business name is available. And then you want to conduct an analysis. You want to look at those names, and a trademark attorney can do this for you. Certainly if you didn't have the budget to invest in a trademark attorney, you could do this yourself. But there's not a red line. It really is a gray area. So it is helpful to have a legal expert help you with this step. Then application, you're going to prepare your application. There are two different types of applications. There's a use-based one, which means that you're already using this name in commerce, and you can prove that. And there's an intent to use application, which means that you intend to use this name in connection with certain services and goods in the near future. And usually I tell my clients not to file an intent to use application unless they plan on, launching their business within about the next 9 months. And it's not just a business, but you can even, trademark a new product name or a new program name, even a new tagline, things like that. But if you're not actually going to be able to prove that you're using it in commerce within about 9 months, really 9 to 12 months, then it's too early to be submitting an intent to use application. And then the next step is attorney review. So after you submit your application, it's usually about 3 months, 2 to 3 months before you're going to get a response from the attorney who is examining your trademark application. This is a government attorney. And if there's a problem with your application, they may issue a non-final refusal. So that means that they're telling you what you need to fix on your application, or telling you that your application can't be approved for some reason. One of the most common reasons is likelihood of confusion. That's why it's really important to do a thorough search and analysis. Now, even when you do that analysis, you can't guarantee that you're going to assess every single name that the attorney may cite in a non-final refusal, because it really comes down to their judgment, their discretion. So there's not a hard line rule. It's really looking at two names, looking at the goods and services that they offer, and making a judgment call about whether you think consumers are likely to be confused about those two names. So when you get a non-final refusal, it's called an office action, and you do have an opportunity to respond to that. The next step is publication. And so this doesn't happen for probably about 6 months from the time that you submit your application. And what this is it's published for opposition. So the USPTO, the Patent and Trademark Office, publishes your name. And basically, it's kind of like in the movies when you saw someone's getting married and they say, "Speak now or forever hold your peace." It's kind of like that. So they give the world an opportunity to reject or to object to the registration of your trademark. And it can be because they say that they have a name that yours is going to conflict with. Or it could be because it's morally objectionable. Any reason by which a trademark could be refused, the world can come forward and make that objection. Hopefully, if your application gets to this step, that doesn't happen. And if it doesn't, 11 weeks after it's published for opposition, it should be registered if there's no opposition. So this whole process is going to take a minimum of 7 months minimum. Not unusual for it to take up to a year if there were any delays for any reason. Okay, contracts. Now let's talk about contracts. So a lot of what I'm going to cover here is going to be relevant to service-based businesses, but certainly even if you are a product-based business, whenever you're doing business with someone else, so you are, selling something to a retailer, if you're manufacturing, or you're buying inventory from a manufacturer, any of those situations, anytime you're doing business, you need a contract. But for the most part, we're going to be talking about service-based businesses. So 5 biggest contract mistakes. The first is thinking that you don't need a contract. This is especially true when you're doing business with friends or, someone that you trust or have a relationship with. You think, oh, I can trust this person, so we don't need a contract. But a contract is not just handy when you don't trust the person that you're doing business with. And in fact, I would suggest that you don't do business at all with someone who you don't trust, even if you do have a contract. But really, I think it comes down to, I don't know where this quote comes from. I feel like it might be a Dave Ramsey quote, but to be unclear is to be unkind. And that is just one of the reasons to have a contract. If you're providing a service, you want to be really clear about what's included in your package, what the terms of payment are going to be. So let's say that you were hired to write a blog article for someone, and you didn't talk about what the length was going to be, or how many revisions there were going to be, or if you were responsible for uploading onto their website, things like this. And so you write a blog article, and then your client comes back and says, oh, can you add this point, this point, this point, add 500 words. And then they want, 2 sets of revisions. And then they say, okay, here's our username and password for you to log on and upload it. Make sure it's formatted in this way. Whoa, that's fine. That's certainly a very normal package of services to offer, but it's very different from if you thought that you were just writing a 500-word blog article. So those are details that you really want to work out and be clear in your contract, so you don't have that misunderstanding with your client. The next mistake is writing a contract yourself. So the analogy I like for this one is if you've ever dabbled in writing code for your website. Now, there are so many, great platforms now that you can get by not writing code. Usually it's pretty easy to create a website these days with Wix or even WordPress. But back when I was first dabbling in blogging, like several years ago, I did dabble a bit in code, when I needed to switch some things with my WordPress site, and I didn't know what I was doing. So I would kind of Google something and then copy and paste some code, and really I was piecemealing it together. And then I would hit the preview button to see what I just did, because it's not just words, like in an article or, something you're writing. it's just words. You're communicating something, but that's what you're doing. You're communicating to the reader. When you're writing code, those those letters and symbols that you put there actually have an operation. So they actually change your website, and I would have to hit the preview button to see what I just did to my website. And then I'd go back and tweak and go back and forth. A contract, the words in your contract are a lot like writing code. It's not just something that you're communicating. The words in your contract have a legally operative function. So for example, let's say you're dealing with copyright. So let's go back to the example of a blog article. And most people would think that if you, let's say you hire me to write a blog article for you. And so I write that blog article, I send it to you, and you send me payment. And so most people would assume that you own the copyright to that because you paid me to create it. But actually what the law presumes is that I am the author and I own the copyright. There is a work for hire exception under copyright law. But it needs to be in assigned writing. So even if you go on one of these freelance platforms like Upwork or Fiverr, or if you are doing your own work, if you're acting as a freelancer on one of these websites, those messages that you exchange kind of, in like a instant message back and forth, that does not constitute assigned writing. So even though there is a work for hire exception, that needs to be in writing in your contract signed by both parties. In addition to that, there are only certain categories that the work for hire exception covers. So if the type of content you're creating isn't protected under one of those categories, then even if you have a contract in signed writing that says this is a work for hire, it's still not going to transfer the copyright automatically. So what you need to do in that situation, so let's say I'm writing the blog article and we intend that you are going to own the copyright to it, or this could be a logo. Let's say I'm creating a logo for you, and of course we intend that you're going to own the copyright to that. You actually have to assign and transfer the copyright to the client in the contract. So that is a sentence, it's a sentence there, but it's not just to communicate with your client or to be on the same page. It actually has a function. When you say that and you sign it, it actually legally transfers it to them. You're sending over those rights to them when you sign it. So it's really a good idea not to write a contract yourself, even if you're providing services that you think are fairly simple, unless you know what you're doing. So third biggest contract mistake, copying and pasting language you find from the internet. Okay, so not only do you not know the source of this, maybe not know if it's appropriate for your business, if it wasn't necessarily a contract that was, written or designed for your niche, but on top of that, that it's also copyright infringement. So someone wrote that. So either a lawyer wrote that, or the person, themselves wrote that, or they purchased a template online. And they, paid for a license. So just like if you're familiar with Creative Market, there are templates on there and things like that. People, they spend time creating these things and then they sell a license to it. Or an attorney drafted that specifically for that person's business. But either way, copying and pasting language that you find on the internet is not only a bad idea because you don't know if it's going to protect you, but it could also be copyright infringement. So point 4, not having a contract that suits your niche. So just like we talked about these copyright issues, there are going to be, different issues that come up in different types of businesses that you want to make sure are addressed in your business. So photographers, for example, there are going to be, of course, issues, scheduling issues, no-show issues, things like, making sure you get certain shots and things like that that come up in photography that aren't going to be relevant for a different type of business. And even within photography, you may have portrait photography or wedding photography. Wedding photography is going to come with, a whole other host of issues that you want to specify and work out in your contract. So, you don't want to use a one-size-fits-all contract unless, you've consulted with an attorney and let's say you're acting as a service provider as an independent contractor, and you have a independent contractor template that you're working off of, and you really customize it for your services. And then that might be appropriate in that situation. And then 5th, using a contract that does not limit your liability. So I see a lot of contracts that are sometimes, sent to me in different businesses I've worked with. Sorry, that's my alarm. In different businesses that I work with, or they are, things that I see other people using, clients of mine that have asked me to check out their contract. And a lot of times when I see someone who's put together their own contract, it's missing a limitation of liability clause, or at least a well-written one. And this is so important. What a limitation of liability clause does is it says, okay, even if I mess up, which none of us think we're going to, but even if I mess up, and you sue me and I have a judgment against me, you and I are agreeing up front that I am only going to be responsible for a certain amount of money. So there's going to be a cap on what I'm responsible for. And that's really important because there are situations where there can be a snowball effect. So let's say that let's say you're designing a logo for someone and you were late on delivering that. You had a deadline in your contract and you're late on delivering that. And they needed to send it for printing by a certain date in order to have materials for an event they were doing or something like that. And so your failure to get it to them on time created this like cascade of events in which they ended up losing more money because of your mistake than what they owed you in the first place. And so what you want to do is you want to come to an agreement about what your maximum liability is going to be upfront, so you don't get into a situation where you're responsible for, every conceivable consequence of this mistake. So maybe you're limiting your liability at your contract price, or at a certain number of months of a monthly retainer if you're on retainer, something like that, but to make sure that you have that language in your contract. Okay, so the next point that we want to go over is what should be in your contract. What clauses do you need in your contract? We kind of briefly went over this in the 5 mistakes to avoid, but so scope of services, you want to clearly lay out what is included in your packages. Get down to really imagining you going through that process with your client and exactly what services you're going to be offering, and imagine, add-ons that they may ask for, and specifically indicate whether that is included in your package or whether that will be for an additional fee. Payment, you want to set out terms of payment again. Do you have a package of certain services you're going to provide, and then additional revisions or additional services are going to be maybe charged hourly? Intellectual property, again, this is the copyright. You want to make sure that the content that you create for clients, if this is applicable to you, is either you are retaining that if you're going to be reusing those types of content, like maybe templates, things like that, with other clients, or if your client is, reasonably assuming that they are going to have the copyright to that you're taking care of that in your contract. For some niches, you may also need to deal with trademarks. So for example, if you're a graphic designer, if you're going to be designing logos for your client, you want to, clearly set forth that your client is responsible for making sure that that name is available and clearing the trademark before they provide it to you. Non-disclosure. So this is, this may come up in your service contract and in other areas of business, but in a non-disclosure, basically you're agreeing that details of your business or details of your client's business is going to remain confidential between you two. Warranties. Warranties is actually where you usually set forth what you're not warranting to your client. So, being sure to say that you're not guaranteeing certain results or things like that, that you're not warranting that, certain things will happen from, as a result of your services. So indemnification is going to be relevant in that situation where you have, for instance, you've created a logo for someone and maybe your client didn't clear that trademark. So the trademark that you're using, the name that you're using to create this logo out of, belongs to someone else. And then they come and they accuse you of, improperly using their trademark. That could potentially be, depending on whether the design is protected by copyright law, it could be copyright infringement or trademark infringement. So you want to include in your contract that for those situations, and then many other situations that can come up in other niches, that your client is agreeing that if they do something wrong, so if they haven't cleared their trademark or something like that, and this could be any scenario where your client is really the responsible party, or maybe they've breached your agreement, and that situation has resulted in a third party, someone other than you or your client, pursuing you for damages. Indemnification means that your client is agreeing basically that they're going to take the blame for that situation, that they're going to stand in your shoes. And within that clause, there's a hold harmless clause. And that just means they're going to hold you harmless. You're not going to be blamed for that. They're going to take the responsibility for it. And then lastly, limitation of liability. We already talked about that. That's where you're setting forth, even if you do something to mess up, or you breach the contract in some way, that they're only going to have a certain maximum amount that they can pursue to recover from you. So that means that rather than you being responsible for all of these unforeseeable consequences of your action, that you have agreed ahead of time with your client what your maximum liability is going to be. All right. Now let's get into website policies. So this is going to be relevant not just for service providers, but anyone with a business. So if a website, that is, if you have a website, you need a GDPR compliant privacy policy and you need terms of use. We're going to talk about what to include in each of those. So first, we want to talk about privacy policy and GDPR compliance. So what does this stand for? It stands for General Data Protection Regulations, and this is a law that comes out of the European Union. Now you may be thinking, well, Kaylee, I don't live in the European Union. I don't have clients in the EU, and I'm not looking for clients in the EU or customers, so this doesn't apply to me. However, this law that was enacted in 2018 is so far-reaching that if you have a website and you in any way collect personal data from an EU resident, you are required to be compliant with the GDPR, and you need a GDPR compliant privacy policy. So what are examples where that may easily come up? So let's say that you have a blog that people can subscribe to, or you have a business where you're offering a freebie, a lead magnet, something that people can put in their email address and download from you to get onto your email list. If someone in the UK visits your website and gives you their email address, then you have now collected personal data from an EU resident. Another simple way that this could happen is if you have analytics tracking set up on your website, and most websites do. So whatever your platform is, Wix or WordPress, whatever it is, a way to track the visitors that are coming to your website and see how many people viewed it that day and possibly where they're located. So when you do that, you're collecting the IP address of the person who has visited your website. And that IP address is personal data. So again, if someone in France or the UK or Ireland comes to your website and you have, Google Analytics or something like that, tracking visitors, then you are capturing their IP address and you're collecting personal data, and you're required to comply with the GDPR. Now, the consequences of not doing that, this is a new law. They're still working out. We're still seeing how really it will be enforced, but the method to enforce it is that a person who believes that you have mishandled their personal data, so an EU resident that believes that you've mishandled their personal data and you haven't complied with the GDPR, they can file a complaint with the regulatory body in the EU against you. So it's not just like only big corporations, are under scrutiny for this. It can just be one person filing a complaint against you. Now, the fines are very significant, could be potentially very significant, upwards of 20 million euros. Now, is it likely that in your small business, you will mishandle personal data of EU residents to the extent that you will be liable for 20 million euros in fines? Probably not, but you don't want to mess around, certainly, with fines like that, and especially a complaint-based reporting system. So because that means that it's not how big of a company you are, it's just if someone files a complaint against you. So you need to make sure that you have a privacy policy that's GDPR compliant, and also that you're, following your policy as well. So that's why you need one. And now we're going to talk about what your policy should contain. Oh yes, again, just warning you, fines of up to 20 million euros. And remember, that is higher than US dollars. Okay, so this is what your privacy policy should contain. You want to tell people what kind of data you collect. So, name, email addresses, IP addresses, any kind of data that you collect, phone number, you want to tell them what data you're collecting. How you collect data. So that might be through, Facebook pixels. It might be through an email list. It may be through data analytics tracking, all of these different ways that you might potentially be collecting data. You want to tell them about that. How you store data, why you collect data. You need to have a legitimate basis for collecting that data. So you can go ahead and read the regulations, or you can, find a lot of blog articles online that set forth all the, legitimate business purposes of collecting data, but you need to tell them why you are. So for instance, if you are collecting email addresses for your email list, that is, they have given their consent. So, and another point about that we'll talk about when it gets to email marketing, things that you need to have in place to make sure that you are getting their consent. But typically, as long as you're, following the right procedure, that's consent-based. There may be other information that you collect, with Facebook pixels, which is, if you don't know, is where you have basically software that is going to track your visitors that come to your website. And this is also linked to their Facebook if they have, cookies enabled, and you're going to be able to to send ads to their Facebook after they have looked at your website. So this is, if you're ever scrolling Facebook and it seems like Facebook is just reading your mind, or, oh, I was just on this website and now I'm seeing ads for it, that's how that's happening. So if you're doing that, then you need to disclose that in your privacy policy. How long you retain data. You can't be, you shouldn't retain data for longer than is necessary, and how and when you share data with third parties. So, for instance, if you have an email subscription software, you may be transferring data to that third party, and those are things that should be disclosed. And then users' rights. So there are several rights that people have under the GDPR. A right to be forgotten, meaning if they want you to delete all of their personal data, they have the right to request that. They have the right to opt out of receiving any marketing materials from you. And they also have the right to know what data you have saved on them. Okay, now terms of use. So this is, the privacy policy and terms of use. These are usually things that you're going to have little links to at the bottom of your website in the footer. And you may, wonder, well, who even reads these things? People really do. If you take a look at your analytics, you can see who is viewing your terms of use or your privacy policy. And I mean, I look at people's privacy policies. I might just be a nerd in that way, but people really do look. And beyond that, again, back to the contracts, there are things that you're including in these that have a legal operation. So you are covering yourself, you're protecting yourself by including certain terms that should be in your terms of use. So for example, you're going to state who can access your website to be in compliance with US laws, and then certain laws of certain states, like California, for example, has specific laws that you want to include in your terms of use, because of course you may have people from California visiting your website. So some of the things that you want to include are that children under the age of 13 are not allowed to access and use your website, that if you're under the age of 18, you need parental consent to use the website. You want IP notices and disclaimers. So you want to, claim the copyright to all the content on your website, the images, your blog content, the copywriting on each page of your website. You're claiming the copyright to that, and also any trademarks. So those are things that you have common law rights to without including this in your terms of use, but you're putting users on notice that you do claim those rights. And then disclaimers. So particularly, these are things that may vary by industry. So if you have a blog article where you're providing, or a blog page where you're providing advice, articles, let's say about starting a business or finance, you want to include a disclaimer that you are not promising that if they follow your advice or implement your advice, that they're going to get any particular result. This is also certainly true if you're in the health or wellness space as well, that you want to be reminding people that if you're not a physician, that they consult a physician, or even if you are a physician, absolutely, you should include that the information on your website is not medical advice, tailored to this individual, but rather that it's educational information. And that, again, that they should consult with a professional for advice about their particular circumstances. So disclaimers like that, that should be relevant to your industry, you want to include there. And then conditions that may terminate their access. So let's say if you have a forum, or you have an area where people can post comments, if people are posting obscene things or harassing others in the comment section, anything that is going to break your other terms of use. So basically, the terms of use is a contract that they are agreeing to, and this will be stated in your terms of use. They agree to this contract with you by accessing and using your website. So if they violate one of the terms of use, they could terminate their right to access your website. So all important things to include. Okay, now legalities of email marketing, and this kind of goes back to our privacy policy. So both for US law, CAN-SPAM Act is one relevant law, and as well as the GDPR, as it relates to EU citizens, there are two things that you absolutely need to have in your email marketing. So the first is consent. If you are collecting someone's email address and you're going to be using that for marketing purposes or to send them emails from your business, then you need their consent for that, and their express consent. So let's say you have, maybe you were at a networking event and you got business cards from a bunch of people and you have their email addresses now. Let's say you have 50 business cards. So having those cards doesn't mean you now have 50 new subscribers to your email list, because they need to give you consent that they actually want to receive emails from you. So if you're offering some kind of, let's say like a freebie, something that can be downloaded, a template, anything like that, or even if you just have a pop-up that says subscribe for updates in our newsletter, you want to have a little box that says by by consenting to this or to receive this whatever it is, template or download or to subscribe, you are agreeing to our privacy policy and to you are agreeing to our privacy policy. So then the other thing that you need to have to comply with both CAN-SPAM and GDPR is you need to give people the option to opt out. And if you are using any of the major email software companies or platforms like MailerLite, ConvertKit, MailChimp, any of those, they have that built in. So as you create your account, you're going to need to provide an address. It can be a PO box. For privacy purposes, you can use a PO box. And at the end of every email, you need to be including that address, your business name, and then an option that they can unsubscribe. So when they click that button and unsubscribe, that they can opt out and say they don't want to hear from you anymore. They want to be removed from your email list, and you need to comply with that. So very important things to include if you're going to be doing any email marketing or having, a newsletter, anything like that. All right, copyright. So we're going to talk about quick, what does it protect? When does protection begin? When can you use someone else's image? And how do you stop someone else from using yours? So firstly, what does it protect? So copyright protects any original works. So this could be a photo that you take. It could be an audio recording that you make. It can be a blog post. It can be a poem. Any original work that you create, you have automatic common law copyright to. And this is true even if you never publish it. So if you are, sitting in bed and you jot down a poem and put it on your nightstand, you have common law copyright to that. Now, when does protection begin? It begins the moment that you create it. You don't need to register it. You don't need to do anything. You have common law rights immediately. Now, there are advantages to registering your copyright, and typically that's something that you would do, maybe for a design, if you have a design that you're going to be using in, for commercial purposes that you've created, or an ebook, or a physical book, something like that. That's probably something that you want to consider registering with the Copyright Office. So when can you use someone else's image or content online? This is huge because, you see people sharing things a lot, and it can be easy to fall into, oh, well, I see everyone else doing that, so I assume it must be legitimate. So when it comes to a photo, there are 3 ways that you can use a photo legally. So the first is that you took that photo, so it belongs to you, you have the copyright to it. The second is that maybe you worked with a photographer and they gave you a license to use that. Or you went to a stock image website and you downloaded an image, legally. You didn't just copy and paste it. You actually downloaded an image from a stock website, and either that may be free or it may be paid, but in that you got a license to use it. So either it's your own photo, you have a license to use it through your photographer or through a website. And then the last is if you are using it for editorial purposes. So, if you see, are they called GIFs or GIFs? GIF, if you're using one of those and it's, like an image and something funny is written on it, then that probably falls under it's fair use. You're making commentary of this. Be careful with that, because certainly, the owner of that copyright may not agree that it falls under that exception, but that's another way that copyright can be used. Generally speaking, I wouldn't recommend that you use any images that you find online unless they belong to you, or you downloaded it either by paying for it, or it was a free stock image that you paid for and you now have the license to that. Okay, and lastly, how do I stop someone else from using my original content? So if you have a blog post, an image, a video, whatever it is, it's your original content that you created, and you see it pop up somewhere else online, that's not a good feeling, and obviously you want that to stop. So there are 2 ways to handle this. The first way is to send a DMCA, that's the Digital Millennium Copyright Act, takedown notice to the web host or the internet service provider of that website. And so when the company receives that, there's a certain way to write a DCMA takedown notice, and you can find templates online or you can work with an attorney. And so the internet service provider, the web host, looks at that and they need to take it down if someone has infringed on your copyright. Then the other way to deal with it is to send someone a cease and desist letter. So this is a legal letter. It doesn't actually have legal force to it. Really, it's just a fancy word for a threat letter, and you can word this nicely or more strongly. This is also true for trademark infringement. So if you see someone using your business name, you can also use a cease and desist letter. Is something that you send to them, and you tell them to take it down and stop using it. And so, like I said, you can word those either lightly, or it can be very harshly worded, or more strongly worded. And basically, of course, the threat behind that is you're telling them, I own the copyright to this material, or I own the trademark rights to this logo, tagline, or name. And, and you are potentially liable for copyright infringement or trademark infringement if you don't stop using it now and take it down. So those are 2 ways to deal with that. And of course, in the online world, it happens all the time. I would say another thing to think about is who is posting that content. So is it worth your time? Depending on your business, you may see certain knockoffs of, maybe posts you make or something like that you've designed, someone stealing like your words and making it into a Facebook post. Just think about is it worth your time to pursue? And sometimes it is, and sometimes it is not. Okay, and then we started with Benjamin Franklin, and we're going to close out with Abraham Lincoln. Give me 6 hours to chop down a tree, and I will spend the first 4 sharpening the axe. What does that mean? It means that you are in the beginning stages of starting your business or you're growing your business, and it is so important to get your ducks in a row, to lay a firm foundation, a solid foundation, so you can just go out there and have confidence that you are going to be protected and compliant, and you're not going to run into issues later on because you did the hard work up front. So if you have any questions about any of the information I went over, the best place to get in touch with me is in my free private Facebook group. It's On Her Way Up. And at the top, you'll see a little post there where you can drop all of your legal questions, and I'll get back to you as soon as I can. Thank you so much for joining me. I hope this was helpful to you. Again, you will have the link. You can come back to this and rewatch any section that you think is most applicable to you. Thank you so much.